So this is a panel that we've assembled at the Kansas City Medical Society to talk a little bit about restricted covenants, which is a topic that's become more and more important to physicians in the last few years as more and more physicians are employed. But really the topic that's been considered a topic of important discussion in medical organizations for years, particularly in the American Medical Association, which is, of course, the largest organization that represents physicians. So we have an expert panel that we've assembled here today that I think could provide a little bit of insight to us with regards to that topic. So my name is Josh Amam, and I'm the current president of the Kansas City Medical Society. So to my immediate right is Ms. J.C. Hurst. Ms. Hurst is an attorney at Kutak Rock. She practices primarily in healthcare regulation, compliance, and business transactions. In addition to her healthcare representation, Ms. Hurst has extensive experience representing and advising healthcare and other organizations in the area of employment. She's also an alumna of University of Kansas School of Law. To her immediate right is Dr. Charles Van Wey, who's a thoracic and cardiac surgeon affiliated with Truman Medical Center. He is a former chairman of the UMKC School of Medicine's Department of Surgery and served as president of the Missouri chapter of the American College of Surgeons, the Metropolitan Medical Society of Greater Kansas City, which is the predecessor organization of the Kansas City Medical Society, and the Missouri State Medical Association. In addition, Dr. Van Wey received the Lifetime Achievement Award and is among the heroes in healthcare in Kansas City from Ingram's Magazine and is named one of the 100 best doctors in Kansas City. He is currently a delegate to the American Medical Association. He'll be speaking a little bit of the perspective of the American Medical Association. And finally, to his right is Mr. Randy Schultz, who's an attorney at Lathrop Gage and is a leader of their healthcare practice. He specializes in healthcare law, insurance, employee benefits law, and corporate compliance. He has more than 30 years of experience. He also serves as an adjunct professor at Rockhurst University teaching corporate law in its MBA program. He's also a CPA and was featured as a healthcare attorney for a nationally syndicated radio program on economics of medicine, as well as a local talk radio show. So we have some really great experts today. And I think we'll begin today with speaking a little bit about what the current organized medicine policy is with regards to restrictive covenants. So Dr. Van Wey, could you speak a little bit about the American Medical Association's position?
Sure can. The American Medical Association has had concerns about physician employment forever. The conditions of practice, the contracts under which physicians work have been a subject that the AMA has concerned itself with for a long time. As I was telling Josh, the way the AMA makes policy is the way a ship picks up barnacles. The policy and the policy is the ship, and all the barnacles stay on it. And periodically, they put a few new barnacles on and maybe take some of the old barnacles off. The current policy for a long time, the AMA was regarded as being implacably hostile to the whole idea of restrictive covenants. And I think there is some truth to that. But in general, the AMA is probably somewhat more skeptical about the value of restrictive covenants than would be, let us say, your average circuit court judge. The problem was addressed by the Committee on Ethics and Judicial Affairs in 2014. And they modified the existing policy to somewhat, and I don't want to read the whole thing to you, but let me just say, covenants not to compete restrict competition, can disrupt continuity of care, and may limit access to care for patients. Physicians should not enter into covenants that unreasonably restrict the right of a physician to practice medicine in a given specialty in a given area, and do not make reasonable accommodations for patient's choice of physician. That, I think, summarizes the way the AMA feels about it. The policy is we don't really like restrictive covenants in terms of restrictions of not to compete after the practice breaks up. But on the other hand, we recognize that there are reasonable restrictions, and I think the question of unreasonably restrict is one of those things that can be interpreted and should be interpreted reasonably by people of goodwill. This comes up at virtually every AMA meeting in some form or another. It's an ongoing process. I don't think there's any reports currently coming out, but this is basically the policy that the AMA has had for some time.
So, Ms. Schultz, and then Mr. Schultz, and then Ms. Hurst, I'll ask you to kind of comment on why these covenants exist at all. What was the inception? What was the rationale? And kind of the background.
Well, covenants against competition are pervasive in every industry that's out there. The basic context is if you're going to, unfortunately, the practice of medicine is also the business of medicine. And like every other business out there, people are looking for competitive advantages. They're looking for ways they can build with capital a business structure, be it a practice or a hospital clinic, whatever it may be. And in order to do that, you've got to make sure that if you're building your assets and making an investment, those people that you're investing in don't immediately just go away and take all the goodwill, take all the intellectual capital that you've developed for them and use it to hurt the business that's trying to grow. We could spend all night talking about the mathematics of medicine right now, the dynamics between physician practices, what their strategies are, hospitals and their strategies. But for all the organizations, they're all insisting on non-compete provisions because of the cost and complexity of building this economic model of medicine in order to be successful in the future.
It's probably relevant, Josh, that the 20 or 30 years ago, maybe 2 or 3% of physicians changed their practice every year. People went to one place and they stayed there. Now, aside from the obvious rise in employed physicians that we're all familiar with, the fact is about 10% of doctors, after training, move every year. Mm-hmm. Most of them move locally, but this is a constant problem for people. So it's become much more of an issue in medicine today than it was, say, 20 or 30 years ago.
Right, and I would echo some of Randy's comments. Of course, there is the economic concerns, right? It costs a lot of money to hire people. It costs a lot of money to train them. It costs in their bonuses. You're paying for production in the initial years that may not be actually coming. But I think some hospitals also have a desire to retain quality physicians. Some hospitals and physician groups work really hard to find the physicians that they think are a good fit for their organization, that will provide excellent care to their patients, and they don't want to lose them. So one reason is, and I'd like to say it's the biggest reason, I don't want to, okay, I'm getting chuckles over here, is that, hospital systems really do want to retain quality physicians. They also want to make sure that they can fulfill the needs of their patient base. It's hard to find doctors in specialties, especially in certain areas of the country. And depending where you are, it's really difficult to attract quality physicians, especially in really specialized areas. So if you lose that physician to a competitor or to anyone, it's going to take you a long time to replace them, and then you're going to have patients that aren't receiving that care. So that is another reason, albeit maybe slightly smaller than just the sheer economics of it.
There's no question that it takes either a hospital or a private practice group a long time to get a physician recruited and on board. Year and a half. Mm-hmm. Big organizations may be able to do it a little better, but I'm not really convinced that that's true. Physicians are not very movable, and it's really hard to get an established physician to leave an area and go to another area in much less than a year. That said, from the physician standpoint, the organization or the practice didn't pay for his or her medical school. They didn't pay for his or her training. They don't pay for his or her continuing education. So the issue for a lot of companies in non-medical is you've got somebody that you spent a year training to do their job. Physicians, by and large, go in and they can do whatever their specialty is right then. So from the physician standpoint, they feel like they're eminently portable. They don't feel that obligation. From the organization standpoint, the organization feels ill-used if a physician comes and then leaves in 6 months or a year. And let me say that organization may be a private practice. I don't want to turn this into a health systems versus private practice discussion, because some of the most restrictive covenants that I've encountered as I've gone through the years have been in private practice groups. Single specialty private practice groups can be very, shall we say, protective.
Or onerous? I mean, he's making a very good point. You know, if you're in an institution, you're bringing in a doctor you can plug and play because you've got patients rolling in. If you're trying to put a new doc into a private practice, you've got a whole new dynamic. You've got to make sure that individual's got the personality to get along with all the staff, gets along with other physicians. And the way healthcare is going right now, you're seeing more and more people subspecialize to the point where they may not know what anybody else is doing in the next room or how to do it. It's amazing how many situations we face where if there isn't a very specific medical issue associated with the subspecialty training of that physician, he doesn't want to see the patient at all. And so building a practice for many of these physicians gets harder and harder in a private practice setting as opposed to a big institution where they can funnel patients into these new physicians. So the private practices want to develop non-compete arrangements so that they can, like I said, preserve the capital, enhance the capital, and make sure that their investment, and it's a big investment over those first couple of years getting docs up and running, so they don't just take off and get hired by a hospital.
It appears that the crux of the issue appears to be that key phrase that Dr. Van Way alluded to, which is the reasonable part of this. So could you help guide us, Mr. Schultz, on what criteria might be that are reasonable versus unreasonable in some of these clauses?
Sure, and that is the big issue. We all have heard of the Stark Law, right? And we're talking about recruiting arrangements, right? And when the Stark Laws came down, the Stark Laws said that thou shalt not be non-competes, and that's it. So nobody thought they could have non-competes. But they've backed up on that in an advisory opinion and said, yes, you can have non-competes in recruiting agreements, so long as they don't unreasonably restrict competition in the geographic area of the institution that's providing the financing. Now, what does unreasonable mean? Now, this is, we could debate for hours if we were taking different positions because it kind of the beauty's in the eye of the beholder, right? But unreasonable typically will mean beyond the scope of geographic area and beyond the scope of time necessary to protect the interests of that employer that imposed that non-compete agreement. But then you've got to analyze, and I'll let you jump in here, what are those interests? Are they protectable? If somebody has a scientific formula for something, right, and they learned it as part of their job, there might be a much larger protectable interest than if someone just comes to work every day, sits down and answering the phone. In theory, they'd never have a protectable interest. Do you want to kind of carry on?
Well, yeah, and what courts have said is that a legitimate business interest that you're allowed to protect isn't just ordinary competition. You're not allowed to impose restrictions that just make it so the guy next door can't compete with you. There are certain things that, depending on which state you're in, they've said are protectable interests. The goodwill you've built, that small physician practice that has worked really hard to build up a patient base, that goodwill is a protectable interest. Referral sources can be protectable interests. Let's see, trade secrets are protectable interests. I couldn't tell you the definition of a trade secret.
Patient lists?
No, I can give you examples of a trade secret, but they're a very specific definition that you try to get into with a trade secret. So those are protectable. You're not allowed to, take patients. You're not allowed to take vendors, that sort of thing. So when you are writing restrictive covenants and when you are thinking about entering into one or signing one, you have to identify whether or not they're just trying to prevent competition or whether they're doing something they're protecting something that's actually protectable. And then the reasonableness factors with regard to the time and the geographic location, but also something to think about is your specialty. You're not allowed to restrict someone from earning a living, right? So a lot of this comes down to what it actually says you're not allowed to do. If you're a pediatric oncologist, for example, they might write a restrictive covenant that allows you to still practice general pediatrics in the area, but just not do the very specific thing that you were doing for that organization. So they have an interest in protecting what you were doing for them. They don't have an interest in preventing you from working at all.
Isn't there sort of a time-specific thing here? In other words, part of the reasonable is you can limit what somebody can do maybe for 2 or 3 years, but not for 15 years.
Exactly right.
Yep.
Most states will impose or allow non-compete provisions a 2-year provision. You always read about 2 years, 2 years. Some are longer, some are shorter. Again, it depends on the facts and the circumstances, and frankly, I think how good your lawyer is and how little the judge may know about non-compete restrictions. But the same thing with geography, right? If you read some of the cases out there, you'll have a big, broad geographic prohibition, but then there'll be a tongue that'll be cut in with specific facilities at which that physician can compete, which they do that in order to soften the reasonableness of the non-compete provisions. I mean, we can get very creative in the way we design non-compete provisions to, if you will, surgically develop a restriction that protects the interest of the hospital, the practice, the clinic, whatever it may be, while at the same time not run afoul of either the federal or the state laws, which of course always have to be read in conjunction with each other.
And so you alluded a little bit to the nuance or the important nuance of which state you reside in, and the Kansas City Medical Society represents physicians in both Missouri and in Kansas. Can both of you speak a little bit to what differences there might be in state or state laws or state precedent?
And there are differences. I'll just start off, and then Randy can go. In Kansas, there is no legislation regarding restrictive covenants. Kansas is all, as is very often the case in Kansas, case law. And so you have to really look at the very specific facts of every situation, see if you can find a case that's similar, and then draw conclusions from that. Missouri has actual legislation, statute that imposes rules regarding restrictive covenants, and then the case law interprets that legislation. And then, of course, the states have, case law has come down slightly differently on 2 years versus 4 years, or 75 miles versus 50 miles, and that sort of thing.
Yeah, and it depends upon the facts and circumstances. The critical thing that physicians need to understand, and institutions, as we've come to find out, is that the big difference in Kansas and Missouri, if you're a Missouri organization, a healthcare provider, a clinic of some type, and because of the growth in Kansas, you just decide to become a Kansas organization and move over to Kansas, if you haven't properly set up your corporate structure in Kansas, those non-competes are not enforceable at all. And there's a Supreme Court case in Kansas right on point. The problem we've got is it's okay for a medical practice to form in Kansas and get authorized to do business in Missouri, but it's not okay for a Missouri practice to get authorized in Kansas as a foreign corporation. And we see just multitudes of practices that started on the Missouri side that have applied to be a foreign corporation in Kansas, and the people in the Secretary of State's office just process the paperwork. But the Board of Healing Arts in Kansas says that if you haven't originated your practice in the state of Kansas, you can't have a practice in Kansas. You're unauthorized to practice medicine in Kansas, and no contracts that a physician enters into with an entity that's not properly set up in Kansas are enforceable of any kind. And we see that issue over and over and over. There's amazing how many big institutions don't realize that's the rule and currently have their huge physician clinics inappropriately set up. It's a big issue. That's probably the biggest issue I find with contract issues between Missouri and Kansas.
That's fascinating. What other nuances are there in addition to the issues with states? How about nonprofit versus for-profit institutions, other structures that make non-competes either or become more enforceable or less enforceable? You already kind of alluded to the fact that some private practices are actually the most stringent with regards to their restrictive covenants. Are there other factors that you've seen?
Well, I think it kind of depends on the bargaining power of the organization and how restrictive they're going to be able to make their covenants, and also the legitimate business interests of the organization, right? If you're a nonprofit operating in this region, do you really have a legitimate business interest to prevent that person from going into a for-profit in over here, because you're not pulling from the same patient base, you're not actually in competition with each other, they're not going to be using anything that they learned from you probably in this other organization. And so you really have to look at what the legitimate business interest they are trying to protect is. And I think that when physicians go to work for nonprofits and there is a restrictive covenant, they should really be careful and make sure that it's narrowly tailored to preventing the competition of that nonprofit. that's something I think should be considered.
And you also got to look at what is a nonprofit as well. You know, those safety net hospitals that really take care of people as you would anticipate a nonprofit hospital doing, like where you work, the wonderful things that are done there. Then we've got other nonprofit hospitals that are just as for-profit as the biggest for-profit brothers around, you know, and they compete just as hard economically and by contract as the big for-profit. So there's no inherent legal difference, okay, other than measuring a reasonableness standard. I think it would be easier to get out of a non-compete provision going against a safety net hospital than it would a big for-profit hospital, okay? But there is no inherent law that says, you know, not-for-profits have an easier or harder time enforcing a covenant not to compete than a for-profit hospital.
And there is something I want to talk about, because we have been talking about sort of enforcing non-competes and trying to get out of non-competes and something like that. I don't want to minimize the pain, money, and time it takes to actually fight a non-compete that you have entered into. Randy, I mean, you can definitely jump in on this. This is something that you want to look into at the front end. You want to negotiate this and really look at the terms of it from the very beginning, because once you've entered into it, deciding whether you're going to fight it or not, there's a lot to calculate in that.
So, Ms. Hurst, that was actually an important part of what I thought was important for us to discuss is, so what should be looked at as these contracts are signed? So let's say, you know, I'm starting my first practice, or I'm moving to a new location, maybe one of them I'm not as familiar with. What details should I look for?
You want to start?
Okay, fine. Obviously, scope and duration, all right? What is the scope of the non-compete? What is the nature of the practice you're prohibited from doing, for how long, and for how big of area? I mean, if your whole family is right here in Kansas City, are you going to sign a non-compete provision that says you can't compete within 100 miles of Kansas City? Even though it may not be enforceable, you've got to go through the rigors of trying to fight that non-compete provision. Whether I'm trying to create a non-compete on behalf of a practice or an institution, or whether I'm a physician that's going to be subject to that non-compete, there's all kinds of tricks you've got to know when you're going into these arrangements on how do we enforce them, how do we get out of them, what makes it enforceable, what makes it unenforceable. I mean, I've represented physicians on both sides, and to have an enforceable non-compete agreement, you want to have a lot of language about why the institution, whatever it may be, has made their investment, what the investment is, what these protectable interests. You want to fall over yourself talking about protectable interests, and yet if you're on the physician side, you'd love it to have it say, well, tell you what, come on over, sign this non-compete, and you can start working. I'll say, okay. Then the question is, what's the protectable interest? Was there separate consideration given for the non-compete agreement? Did the employer breach the contract somehow that would make the non-compete provision unenforceable, and do you build traps into your employment agreement that the employer can breach to give your client, a physician, out? And therefore, on the hospital side, or the institution side, you want to make sure that you're drafting these provisions to make sure that those little opportunities don't exist from a legal perspective.
One of the things, you know, I spent most of my career in academic surgery, and I've probably had a hand in training 200 or 300 surgical residents over the years. And one of the things that we fail to do is we've absolutely failed to give them enough grounding in this kind of thing. But the one thing that we do is to tell them, look, don't sign anything without getting advice, and we have lots of advice. This local society has legal help available. The state society does. The AMA actually has a contract center and will respond to queries from people around the country who are trying to find some way that they can review their contracts. The worst thing that we see is people sign a contract without really looking at it very carefully, and then, oh my God, I want to get out of this. Let me go back and read that.
So I want to explore that issue just a little bit. Certainly in contracts in which, or in organizations in which there are 2 or 3 members, the contracts often are negotiated. But many physicians now are joining much larger organizations where there's almost a template contract or a template restrictive covenant within the contract. how much of that can be negotiated?
And I will say it's not, almost a template. It is a template, and they will say, you can't change this at all. Some of them mean it, and you just have to live with it, and some of them don't. I think something for people to consider when they're looking at these contracts is they think if they contact a lawyer, they're going to end up in some sort of battle, some sort of negotiation back and forth. And I don't think that that's true. The lawyer can just help you understand what the provisions mean, right? There are tricks, as Randy called them. There are little things that they put in, and there's a reason they've put those there. And a lawyer can help you understand what the reason is that that's there. Oh, they put that there so that it means you can't X, Y, Z. And it's something that you wouldn't necessarily see just from reading the agreement. So, have a lawyer look at it, even if you're not wanting to engage in hand-to-hand combat battle about it. And so I think with the sort of template ones that the big groups are saying, this is non-negotiable, some of the things I've seen them doing are the restrictions change depending on how they've classified your position, right? So depending on the type of physician you are, you may have a broader geographic range and a longer time, or a shorter range, et cetera. So one of the things you can consider is how you're getting your position classified. That then you're still using their template, but you're working within their system to really minimize the impact of that template on you. And then the other thing is, if they really mean it, which some of them really do, it's non-negotiable. They have the power to just go get a new one of you. Just understanding what those terms mean. But I think some of the things that are negotiable, I've often get people to change the geographic mileage, and that's something that you really have to think about. It says 20 miles. Okay, does that mean 20 miles from the main practice? Does that mean 20 miles from every single office that I've ever practiced in? And where do I want to work that's 20 miles from here? And sometimes they will let you say, okay, 20 miles except hospital X or hospital Y, or except for county X or county Y. I also have had, we've had luck negotiating every single term in a non-compete agreement. It just very much depends on the organization that you're working with.
Well, and two, even the big organizations now, I hate to say it, but more and more everything's coming down to business and economics of healthcare, right? And they've got a business plan on how they're going to utilize whatever physicians they're going to have, and that plan has been approved by a big hierarchy, and there's people at the local level that are hired to and told within the institutions to enforce that mandate, find those physicians and put them in place. Well, you've got a whole range of issues you negotiate, from compensation to non-competes to vacations to hours you're going to work to call coverage to, 1,000 different things that you can negotiate, and the non-compete provision just becomes one of those many. And if you're a physician that has serious interest of being able to stay in one area and not being locked out of that area, well, there's other areas you can compromise. We negotiate every non-compete provision that we deal with. One of the big systems in town says that we won't enforce the non-compete if you go back into private practice, right? But then they come along and all of a sudden you get a contract, that little phrase doesn't happen to be in there. Then you just remind the people you've dealt with over forever that, hey, remember we used to have this provision, we want this back. And more often than not, they'll say, I think we can work that out. So there's, again, the reason you want to utilize someone who's got experience doing this kind of thing is that there are ways that you can maneuver and accomplish everyone's objectives if you do it in a positive, constructive way, and the non-competes do have some flexibility from that perspective.
So let's say, like many physicians, you weren't as proactive in that initial hiring process or the initial time you took that job. What opportunities are there to reevaluate the non-compete after you've already started employment, or a few years into employment, or many, many years into employment?
Well, every time your contract term comes up, that's a time to look at all of the provisions of your contract. And a lot of times, practices or groups or hospitals are working with new templates at that time anyway, so they're going to put a new template in front of you to sign. So that's a good time to look at those terms. Anytime you're talking about new compensation, any change in the terms of your employment is a good time to talk about it. Right before you're wanting to leave is not a great time to talk about it. So you want to pre-plan a little bit for that.
No, I think that's exactly right. And watch what's going on wherever you're working. if there's people they just let out of their non-competes, find out why and how from those individuals if you know them. All right, create a little book of your own on, what were the circumstances, what allowed those people to get out. Because if someone gets out once for some kind of reason, then we try to leverage that reason as much as you can. Obviously, when you listen to us talk, we're advocates. That's what we do. We're designed to either attack to get out or build a document to enforce. And we spend all of our time doing those kinds of things. But you've got to realize, like any other type of relationship, the big three, what are you going to do, what do you get paid, and how do you get out, right? And when you walk in, you've got to answer those questions. And after you're there for a period of time, you're just tired, you want to do something else. Well, now there's a whole other realm of ideas that we come into, and how can we get someone out of a non-compete that's been working for 15 years. They may have built up enough goodwill in the marketplace and become so subspecialized that the bigger institution, the physician group, whatever it may be, may find a way to allow that person to do something that they want to do, either outside the non-compete, or in fact, we've also got situations where we have institutions and physicians where we're building a new practice niche. Okay, which brings more value for the institution, whether it's a practice or a hospital or system somewhere. And as consideration by the doc for developing and expanding this practice niche, if it becomes successful, they can get out of their non-compete. I mean, there's just a whole lot of different ways to go after changing the current situation based upon getting back to the quality of the physician, the business attributes of the environment, and what other physicians are available to step in and take the place. Maybe if you recruit a new doc to train that doc with everything that you're currently doing, maybe the group will allow you, or the institution will allow you out of your non-compete. And again, there's just every kind of scenario you can imagine. The point is, don't think you're locked into anything. The first time someone says, no, you can't, you realize you're talking to the wrong person.
So one group that we haven't spent much time talking about is probably the most important group, which is patients. And one of the concerns that the American Medical Association had was regards to continuity of care. Dr. Banway, could you speak a little bit about that portion of the AMA statement?
Yeah, I can. And there's been a fair amount of, when this thing came up, this latest revision in 2014, there was a lot of testimony and discussion about how do these things affect patients. And they can affect patients in a number of ways. A lot of it depends on the kind of doctor you're talking about. If we're talking about a radiologist, maybe they aren't going to see a lot of patients, but they may be very important to the hospital because they bring very specialized skills. On the other side, if you're talking about a general internist who's got a book of 2,000 or 3,000 patients, that's 2,000 or 3,000 people whose lives may get disrupted when he moves across town. And if he's then unable to move across town or is under restrictions, it can be very difficult for them. At the same time, the institution then is in the position of maybe losing those patients. And I could give you a number of examples locally where that sort of thing has actually happened, as I'm sure both of you could.
We won't.
I'll try not to.
So without any specifics, what have you, or maybe with specifics, what have you seen with regards to how the law or cases have dealt with that issue with regards to continuity of care, moving practices, patients that want to continue to follow their physicians, how records are dealt with in those situations, things of that nature?
I've had colleagues at both extremes. I mean, I've had people that have left a practice and been unable to access the records of their patients. Practice takes a position, we own the records, you can't have them. And they've gone out into a different practice environment, maybe just across town, and basically they have to start over again, even with their old patients. On the other hand, I've also seen much more amicable moves where people can access records of patients that they've had and even take a fair number of them with them. In some ways, I think the larger and more specialized the practice, the harder the problem is. The smaller, but that may be an overgeneralization. Now, I've spent more than half my career in one safety net hospital or another, here or in Denver, and I had the feeling that the safety net hospital is somewhat of a different problem, because in those, the patients tend to be tied to the hospital. So if a doc leaves, patients don't go. They're there. They're at Denver General Hospital, to take one of the examples. And if somebody moves over to St. Anthony's, they're not going to expect their patients to come with them, and most of their patients won't. A few will, but most won't.
It's interesting. I've got a case right now in Denver with 2 female breast surgeons, okay, that are part of a big group. One of them's at a safety net hospital, the other one's at a very for-profit hospital. The safety net hospital is basically saying, boy, we hate to lose you, but good luck with what you're doing, you know. And of course, the for-profit hospital that knows that this physician, she's everything you'd want. Just wonderful, intelligent, dynamic, great with patients. They're fighting like crazy, so the practice group, you know, doesn't impose any non-competes on her. So you're right. The dynamic of the institution, the dynamic of the patient situation. I mean, patients can always take the records wherever they want to. That's the fundamental issue. You know, the hospital, the docs, they can't say, no, you can't have them. You know, the old Clint Eastwood thing, you know, make my day. If I want my records, I can have my records. Now, you get all the HIPAA authorizations, yada, yada, yada. But the patients can always have their records, and they can take those records to the physician. But just because the patient has their record doesn't mean they can see their doc if their doc's precluded by a non-compete from taking care of them.
Yeah.
And that's the hard part.
Yeah. JC, you've worked in the safety net environment.
I have, yeah. I don't want to speak to any one safety net in particular, but I think there is a different dynamic. Part of it is because of that sort of legitimate business interest, but also the patients aren't as mobile. I mean, they just aren't. When you're practicing in a real safety net situation, you are seeing a different type of patient and a different set of illnesses, and the patients are really tied to that institution. And sometimes they're getting transportation from the institution to come there. And so when the physician moves, you really do have a complete change in care. So
I imagine that most patients are not aware of restricted covenants or frankly are not familiar with this area at all. Is there a way for patients to be aware or a need for them to be aware of this issue? I mean, if their physician moves to another location that they may be precluded from taking care of them?
Really, no. There's no way you can do it. I mean, I give some presentations, and I always say the same thing. You've got a son or a grandson or a daughter or granddaughter that slides into second base playing softball or baseball, and there's a bone sticking out the ankle, okay? Are you going to shop for an ambulance? Are you going to shop for a hospital? Are you going to shop for an orthopedic surgeon? You know what a vascular surgeon is? You do, of course, but they don't. You know, what about a pediatric anesthesiologist? Are they going to ask somebody, is there a non-compete provision that's going to affect my son or daughter? I mean, the problem we've got, or the factual situation we've got, is that the public can't even begin to evaluate healthcare. You know, is Dr. A better than Dr. B? Is institution A better than institution B? I mean, the information is, it's becoming more and more because you're seeing more information out there, but I would argue for the large portion of the population, they don't have a clue about any of this stuff, and all they know is when they need help, and they trust every doctor to be as good as every other doctor out of the chute.
I'm going to go a little different on that one. I agree. I don't know that it is necessary for patients to know about, but I'm a person that shops doctors really specifically. I can be a difficult patient. I'm a lawyer, so all of you physicians are like, no, thank you. I ask a lot of questions. I need answers. Sometimes you're going to have to cite a reference for me, and so I shop pretty hard for my doctors. And so realizing that something could happen to where I would have to switch, and I live in a smaller community, so I would have very limited other options, is something that actually does concern me, especially with a really specific type of specialty doctor or something.
Well, JC, you know, lawyers really are the
Worst
the
patients.
second worst patients. The worst patients, of course, are
Our
doctors.
doctors.
But
They're also terrible clients.
I tend to go along with that because, of course, in an emergency, you're going to go to the institution that can take you. But if you're looking for an internist to take care of you for the next 20 years, you're very likely to be looking at things like what sort of system are they in, what sort of practice are they in, how likely are they to stay there for the next 20 years. and all of those things. That said, I'm not sure how far up on that list the existence of a restrictive covenant is going to be.
I don't think it's,
I don't think it's very, I agree with Randy, I don't think it's very high on that list. But, you know, are you willing to cite references? It's pretty high on the list for me.
So risking messing up the ability to record. Anyone in the audience have any questions that we haven't covered?
I'm just curious what the Kansas City market is. I'm a private practice guy, solo. Just if I hire somebody, what's kind of the going expectation of a non-compete in this day and age, Randy?
I have all spectrums. I have some really large groups that don't do a non-compete at all. However, it is becoming very difficult for them to hire, for those groups to hire, because a lot of people have non-competes. And it's becoming a really tight market for that. What do you think, Randy?
You know, I usually see a 2-year non-compete within a 10-mile radius of the practice. That's a very standard non-compete provision.
Other questions? So both Missouri and Kansas are quite rural states and obviously relatively underserved in terms of physicians. Compared to other states, what have you seen different in Missouri and Kansas vis-a-vis other states because of the geography or the demographics?
I don't know if you can really say it's because of demographics or geography. You know, Colorado, there's a law in Colorado that says there shall not be any physician non-compete provisions. Okay? So there are no physician non-compete provisions enforceable in Colorado. However, if you have damages, you can have a damage provision, and the damage provision is enforceable. So whether I'm on the institution side or on the physician side in Colorado, we always include non-compete provisions, but we spend our time focusing on the language of the damages provision because that's what's enforceable. Okay, yeah, you can compete, but you owe us, you know, $250,000 if you do that, right? And so the different states have their different approaches for these things. I think you're getting down to reasonableness again. If there's only one doctor in a 75-mile area, I think it'd be hard-pressed for a judge to enforce a non-compete because you're leaving a community or a geographic area that's underserved. And that's, like I said, these are all facts and circumstances, and I think the reasonableness of the restriction will be predicated to some extent on the number of physicians and the types of physicians in the area. You know, you're an ENT. Well, someone makes an argument that every primary care doc practices ENT, right? You know, so it just, all these, it's almost like an antitrust analysis, which we're not going to get into, but the whole issue boils down to what is reasonable given the fact situation that you want to put out, the subspecialty of the physician and the area involved.
You know, that raises a point, which is that leaving then becomes a negotiation as well. And I'm aware of one practice that split, and it was an unusual situation, but to make a long story short, they wound up negotiating over how much of the accounts receivable the docs who were leaving were allowed to take with them. And I think the negotiation was very little of their accounts receivable, but that's the kind of negotiation that people get into.
It is, and part of it then becomes, you know, are you willing and do you want to fight the non-compete? I have seen some non-competes that you look at them and you're like, this is not reasonable. You've seen the case law, you're like, this is too many years, this is too many miles, there's no way that they can enforce this. And then you have to go through the steps with the client saying, and this is how we fight it, right? You do a TRO, you have to go through the thing, it takes time and it takes money, and there's a risk. Sometimes they don't ever try to enforce them. I mean, we've all seen that, where they just don't. But that's one of the things you have to think about when you're leaving is how willing are you, how much time and money are you willing to put into fighting it if they do fight it.
So how does a physician who takes that risk of leaving and then trying to determine whether or not the non-compete is going to be enforced, do they just start their practice and see what happens, or do you explore with the other organization?
It depends on the personality of your physician, obviously, but in a lot of cases, you know, ask for forgiveness, don't ask for permission, one of those types of scenarios. But this gets back, you know, as we were talking about before, the contract is put together in the first place, right? You know, if And of course, like a lawyer, I can take positions whatever side I'm representing. If I'm representing the institution, if I say that the physician has breached the contract or allegedly breached the contract, and we've got to engage in litigation or legal fees to try to correct that breach, the physician has to pay all the legal fees as a matter of contract. And of course, I'm on the physician side, it's just the opposite. I say that if the institution comes after us for something and it ends up being the institution's at fault, the institution has to pay all of our legal fees. Because, you know, it's sad, but in a lot of litigation now, the amount of legal fees to be incurred, you know, it's a cost-benefit analysis, right? The smartest advice we can give anybody is make sure they go to a lawyer that knows what they're doing before they enter into any type of non-compete restriction, so that the whole contract can be looked at and we can build a whole offense or defense, depending on our position, up front, so that, okay, you know, I think I might want to move here down the road. Let's talk about that, you know? Or somebody in my family may want to do that. Okay, let's talk about that. And you might be able to build into a contract a very unique, specific circumstance, you know? If my spouse has a health situation where I need to be here, I'll be out of my non-compete and I don't have any damages for leaving, right? Mm-hmm. So there's a whole dynamic that goes into, it's like anything else. It looks really simple when you read a sentence that says thou shalt not compete, but the dynamic that goes into designing the entire contract relationship and all the intricacies that go together and all the gives and takes and take backs, that's the dynamic where you really want to make sure you're going to someone who knows what they're doing, so that we can pre-build for you whatever environment you want to be in, both current environment and then on the exit side. What do you got to do? What do you get paid? And how do you get out? That's all any contract is.
I can ask one question. I actually mentor a lot of residents and fellows across the country. I teach a bunch. What does it cost if I give them advice to come to someone of your guys' quality? You know, residents and fellows have no money, so they don't read this. I've been in that situation. Is it a $1,000 bill or a $10,000 bill they should expect to have someone of quality look at a non-compete for?
Randy and I probably have different rates, but
Just so I can tell something.
no, but I think it depends on what you want to do. I have done this for people before, where I've said, you know, what we can do is look at it and I can tell you what it means, right? And that's a 3-hour thing. Mm-hmm. So that's very different than entering into 6 months of negotiations about a contract. So I think it depends on sort of what they're needing. It can be done in as few as a few hours, just if you just want to know what it means. But
That's so very well said, because the question becomes, do you want to know what it means, or do you know how it is affected by your entire contract? All right, and what dynamics do you need to think about when you're entering into, maybe it's smart to have a non-compete in a certain context, all right? Because if you're entering into a group that's got dynamics that could make you, you know, be extremely successful in the quality and the nature of your practice, okay, but you've got to make sure that you're looking at everything else in the contract. Where are the escape valves? Okay, is it okay to sign a non-compete? Okay, the non-compete says you're going to be non-competing for a period of 2 years once you leave and in an X mile radius, all right? Can you compete while you're still working? Right. Were they smart enough they wrote the provision that says that during the term of this employment and for 2 years after you're not going to compete? We see that all the time, right. You know? And so you're right. It boils down to, we can sit down very cost effectively and look at a paragraph and say, well, here's what it is, here's how it works, and here's what the law says in either state. Give us a little bit more of your circumstances so we can evaluate the reasonableness side of it, and there you go. But it's kind of like...
Just great attorneys, by the way. That's the doctors. I mean, you know, just, again...
It depends.
Yeah, I mean, but do you tell a fellow $5,000 squirrel away for this consult, or do you tell him $2,000 to squirrel away? Is to get a good answer.
All right, they really can't quote prices,
Yeah.
but I can tell you what I tell my residents,
Thank you.
which is plan on spending $1,000 or $2,000.
Mm-hmm.
That'll get you a few hours with a lawyer. It'll get you through the contract. If it's a bad contract, maybe you've got 2 or 3 places you're trying to decide. Maybe you want to go back to the person who gave you the contract and said, I want you to do this, 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 and this. Maybe you want to reconsider because this lawyer to whom you just paid some money has told you, you know, this is a pretty onerous, to use your term, contract. Maybe this is telling you something about the organization.
Very good point.
Yeah, and one of the things also, just we were talking about those little things that it doesn't say you can't compete while you're there, or it doesn't say you can't, it says you can't do this, but it doesn't say you can't start up a company where you're kind of the second guy that does it. One of the things to look at also with that are the termination provisions. I have seen non-competes where they've decided to stop operating, and yet the non-compete seems to still be enforceable, right? They have shut down the organization, yet the way it is written, they would still enforce a non-compete. So look for just insane things like that are just so completely not reasonable, but you don't want to fight about that later, right? And it could just be poor drafting. A lot of times it's just poor drafting. It's not what they intend at all, but you want to catch that on the front side because it's far cheaper then.
Well, let's just look at the ABCs of a very simple non-compete provision, right? The non-compete provision should read like this, okay? You've got a non-compete provision for 2 years and 10 miles from your practice location or from the whatever facility, all right? But then you want to add in a provision that says, if I'm representing the physician, and even the institution anymore, if the institution terminates me without cause, they just let me go, should I be subject to a non-compete? And most institutions won't enforce a non-compete in that situation. If the institution breaches a contract with the physician, Missouri law won't allow that non-compete to be enforced. Now, if I'm a physician, I just quit. Well, yeah, it should probably be enforced against me. If I breach the contract, well, yeah, it should probably be enforced against me. And these are the kind of discussions we have every time along these lines. The big out for the docs are the hospital or the institution or the practice terminates them without cause, or somehow that entity breaches the contract. Those are your two classic outs of a non-compete provision.
So our discussion so far had really been with the practice of medicine, which is of course what most physicians do with most of their time. But many physicians also have leadership roles now in organizations, and those have associated non-competes of some fashion, or at least restrictive covenants, I should say. Could you both speak a little bit to that, what usually those restrictions involve with regards to leadership positions in other organizations, and how those limitations are dealt with?
You know, in practice, you normally don't see, if you're the president of the corporation, you can't be, or an officer in the hospital, you can't be the president or the officer of something else by itself. What it'll say is you can't be affiliated with a competitor in the capacity of as an owner, officer on the governing board, or as a provider, something more general like that. Everything's got a different design element, and it depends on who the individual is and what they're trying to protect. Okay, we very frequently are able to create arrangements where there's some type of carve out, so there's not an exclusion from any kind of similar activity. But I mean, ambulatory surgical centers, right? I mean, how many provisions out there say that if you're part of this ambulatory surgical center, you can't refer patients to another ambulatory surgical center, right? You know, I mean, they're all over the place. So that gets more to a specific prohibition, not so much with patients, but the facility at which you can provide any dynamic of service, whether it's medical director, administration of other types, providing services there, referring patients there. That's the kind of thing that we see.
And this is an example of something that's kind of borderline by the AMA Code of Ethics. You know, because it's restricting how you can deal with patients. You may have entered into that restriction voluntarily because you own 1/16 of the ambulatory surgery center, so it's in your financial interest. But then is it in your patient's interest that you are restricting yourself to that extent? And that's one of those, is it reasonable questions?
Yeah, because I think you're alluding to, Dr. Van Wey, the AMA Code of Ethics is actually specifically critiques physicians for entering into these type of arrangements.
Exactly, yes.
But the whole concept, I mean, let's go even a broader scale then, okay? Star Clause, physicians can't own hospitals now, right? They participate in Medicare. Why? Because they're afraid that the physicians are going to refer to their own hospitals. The federal government's putting a restriction on the practice of medicine from an economic perspective. Two orthopedic groups can't share an imaging center, right? because they can't satisfy an office ancillary services under Stark. So we're legislating away competitive environments. So if anybody wants to pick on a non-compete, that's like a little puppy compared to the bigger issues we have on how you design the integrated delivery strategies. You know, the antitrust laws. 3 physician practices can't come together in a room and say, tell you what, let's charge the big payer X% of Medicare. You do that, they all go to jail for price fixing. Bam, that fast. It's got nothing to do with the big monopoly like you normally think of when it comes to antitrust, right? And so our whole legal structure, our whole environment is designed to drive economic ends and to try to facilitate as much as you can physicians from utilizing their own services in any way to increase the cost of care. You know, and the non-competes are being used just in exactly the same way. You know, we want to tie up our group of referral sources. I'm an institution, I'm going to hire all the primary care doctors in this geographic area. I'm going to tie them up with non-competes. Now I know I'm getting all those patients from that area. Now, what does that have to do with patient care? I'm sorry. You'll need to fill me in on that one, okay? But that's just the reality of the marketplace.
It is, and to a point, that doesn't necessarily affect patient care.
I agree.
In other words, if there are 4 ambulatory surgery centers in town and you're tied to one of them, is that necessarily bad? And maybe you can provide better service if you're tied to one than you can if you're trying to scurry between 4 different centers all around town and being late every time you get to one.
Stark only lets you have 3. No, and a kickback statute actually only allows you to have 3, but that's a whole nother issue.
Let's not get into it.
Do we have any other? Yes.
I have a housekeeping question and then a follow. What, you used the term TRO. What does that mean?
Oh, temporary restraining order.
Okay.
Sorry.
So the example I think, Randy, you talked about, ask for forgiveness. So, you know, a physician tempts fate, moves to a new group. Could you talk to us about tortious interference with these agreements from the courtship side for like where they're going? And I've certainly seen a lot of non-competes, and nowhere in there does it say, doctor, you're supposed to disclose to whomever that you have this agreement. And I think that's important for our audience tonight too.
Yeah, why don't you ask him about thoracic surgery? I mean, the whole concept of tortious interference is a very complicated area of the law. It's very hard to enforce. Lawyers like to throw it around, you know, because it sounds neat, you know, but you've got to show that there is a protectable interest and someone had the intent to violate that protectable interest. Going after another employee is just competition out there. People try to hire people all the time, and just because they have a non-compete doesn't necessarily mean it's tortious, you're tortiously interfering with that person's contract. Do you want to play with that one a little bit?
Well, yeah, I mean, you are right. It is important for people to disclose. Typically, when you're entering into a new employment agreement, I don't know, a lot of people don't read them, but what they say is, I have the ability to enter into this agreement. There's nothing that restricts me from not entering into this agreement. So if you have a non-compete already, you're breaching your new agreement if you haven't told them. So yes, tell about the non-compete, and then let that other entity evaluate the risks, and they do all the time, of whether they're going to hire you anyway and fight about it, or enter into negotiations. I have seen some really amazing negotiations with an entity that wants to hire a physician and buying them out of their prior non-compete. So that's entirely possible. There's usually a price on everything.
Any questions from the audience? Well, I think this has been a really excellent discussion. Believe it or not, it's been an hour that since we've started talking, and the time has really flown. So I want to thank the panel very much for this really great set of comments and very enlightening to this situation, which I think is something that most physicians are really quite uninformed about. So thank you very much.